Namaste. Welcome back to the Conflict Management through Mediation course. So, we are in week 4 of the mediation course. In this week, we were been discussing various chapters of Mediation Act 2023, and in this chapter, we will discuss about chapter 10 of Mediation Act 2023, which talks about the community mediation. So this chapter focuses on community mediation, that is a process designed to resolve disputes that threaten the peace, harmony, and tranquility of the community. This chapter outlines the procedure for initiating community mediation, the constitution and the composition of panels of community mediators, and conduct of mediation process for resolving community disputes. So this chapter provides a framework for community mediation, and with this chapter the act aims to foster amicable resolution within the communities, thereby preventing escalation and maintaining social harmony. To put it in other words, community mediation means it is neighbors helping the neighbors to solve problems and resolve disputes and bringing justice at the doorstep of the people. It is meant to provide an opportunity for citizens to participate in the prevention and early intervention of conflict as an alternative to the institutional mechanism. So let us discuss a section wise what the community mediation talks about in this chapter. So first, let's discuss the first section of this chapter. It is section 43, which deals about initiating community mediation. So section 43 lays down the scope for mediation, community mediation, and it applies to the disputes likely to disturb peace and harmony of an area or locality. And in case if such conflict or a dispute arises, then it should be resolved through the parties themselves, which requires a prior mutual consent of all the parties involved in these disputes. Ensuring this section ensures that disputes affecting communal peace are resolved amicably, preventing the potential and conflict and fostering the community harmony, which is very much essential for the community at large. Moving on to the next provision of section 43, that is section 43 clause 2, it asserts that any party to a dispute can apply for community mediation. So there is no need that both the parties has to apply. Any party to the dispute can apply to the community mediation, and such application can be made before the concerned authority, that is the authority established under Legal Services Authorities Act of 1987, or the mediation cell established with district or subdivisional magistrate, where no such authority, like in case if if authority under legal service under the Legal Service Authorities Act 1987 is not established in your locality, so you can apply such cases with the district or subdivisional magistrate. And this provides a clear pathway for the parties to seek mediation, ensuring accessibility and formal recognition of the mediation process. So this is where the provision lays down what actual the parties are required to do to opt for mediation, that they are required to apply with the legal service authorities. In case if legal service authority is not there, then they should apply with the district or sub-district magistrate. Further, this provision also lays down the constitution of mediators panel for resolution of community disputes. So it lays down that the authority or magistrate will constitute a panel. So that means for a community mediation, with whom you have made the application, or the dispute parties has made an application. If they have made an application with the legal service authorities, then the legal service authority will constitute a panel. If you have filed an application for the resolution of community dispute with a district magistrate or sub-district magistrate, then the sub-district magistrate and the district magistrate has the power to constitute a panel, and that panel should consist of 3 community mediators. So upon receiving an application, the authority or the magistrate, as the case may be, shall constitute a panel, and that panel should consist of 3 community mediators. The purpose behind inclusion of 3 community mediators is that a dedicated team is formed to handle the mediation, promoting structured and focused dispute resolution. Along with that, so they have included community mediators. This is only because such community mediator themselves will know like what is the actual dispute, and that is why they have included the community mediators to be present. The next provision lays down with respect to the notification of permanent panel. Even the authority or the magistrate shall notify a permanent panel of community mediators, and this panel may be revised periodically. Further, this provision establishes a ready-to-serve panel of mediators, ensuring prompt and effective mediation services. So having a permanent panel of mediators will make sure that the team is dedicated only to handle the mediation of a community disputes, which will promote a structured as well as a focused mediation resolution, and even it will lead to a possibility of speedy justice by means of mediation. Having a permanent mediator panels will be well experienced, and that is a value added to the community mediation. The The next provision lays down the composition of panel, and for the composition of the panel, the eligible persons are the persons of standing and integrity respect in the community. So the person who has a high standing and integrity respected in the community, local person recognized for their contribution to the society, representatives of area or resident welfare association, persons with experience in mediation, or any other person deemed appropriate. So, having the composition and the eligibility criteria that has been laid down in the provision ensures the panel includes respected community members and experts, enhancing the credibility and effectiveness of the mediation process. So having the experts, the local community mediators increases the credibility. The next provision talks about the representation. So basically, when we talk about the representation, there are n number of representations which are required to be present so as to make fair justice. Basically, most of the courts, the panels, the composition, wherever the authority or any composition that has been framed, there has been a reservation for or a representation is been required amongst women's or other classes like disabilities and others. So even in this case, the composition should also have a representation of a woman or other classes or other categories of persons to be considered. This promotes the inclusivity and ensures diverse perspectives are being represented in the mediation process. So this is all about how the case is required to be instituted and what are the composition for resolution of community disputes. Moving on to the next section, that is section 44. This prescribes about the procedure for community mediation. So a community mediation should be conducted by a panel of 3 community mediators, as we have already discussed with respect to the composition of community mediation. And the procedure laid down is that the mediator devise a suitable procedure for resolving dispute. So the panel of mediators, that is 3 community mediators who is appointed for the resolution of community mediation, they will devise the terms how the mediation is required to be conducted and or what is the suitable procedure for resolving of such mediation disputes. This allows the flexibility to the mediators to tailor the process to the specific needs of the community and the nature of the disputes. Further, the provision also lays down that the mediators strive to resolve the disputes amicably, like they should strive to resolve the dispute amicably by providing assistance to the parties by means of facilitating for the resolution or amicable resolution of the disputes. Again, all the principles of mediation are applicable to these mediators. All the procedures, the roles, the duties of the mediator is required to be adhered by the community mediators as well. And this endeavor aims to achieve a peaceful settlement that preserves community harmony. The next provision in relation to this, with respect to the procedure that is laid down is the settlement documentation. Wherever a settlement has been reached with respect to a community mediation, that settlement should be drawn in writing. So agreement should be drafted and such agreement should be written format and it should be documented and signed by the parties and authenticated by the mediators. In case if if the community dispute is not been resolved, in case of that is non-settlement is reached, a non-settlement report is submitted to the authority or magistrate and the parties. So this ensures that the outcomes of the mediation are clearly recorded and communicated. So this section or this provision ensures that the settlement agreement is recorded and communicated, which will help in enforcement of such agreement. The purpose and enforceability. The next provision talks about the settlement agreement aims to maintain peace and harmony, but the community mediation, the settlement of a community mediations are not enforceable as that of a civil court judgment or a decree. Because civil court judgments or decree discusses about the individual rights, but whereas the community disputes, it resolves or it is for the peace and harmony, or it is in relation to the peace and harmony of the society. And how the peace and harmony should be strived, it cannot be calculated in terms of money, neither it can be calculated by means of any other means which we can make enforceable. So that is why we feel, or it's my opinion basically, that it may be wrong as well. That is why the provision is been included under section 44 that community mediation, settlement of a community mediation should not be enforceable as that of civil court judgment or a decree. This emphasizes the community oriented nature of settlement, focusing on maintaining social order rather than legal enforceability. Another provision included in this section is that, as we have already dealt section 20, that all the settlement agreements reached by means of mediation should be registered. And similar provision is been included under section 44, that is registration of community mediation agreements. This ensures consistency with the other provisions or other types of disputes with the community mediation and formally recognized and registered, providing a record of settlement. So overall, chapter 10 of Mediation Act 2023 establish a structured framework for community mediation, emphasizing the importance of resolving disputes that affect the community peace and harmony. By defining the process of initiating mediation, constituting panel of mediators, and outlining the conduct of mediation, this chapter ensures that community disputes are handled effectively and amicably. So community mediation also helps in restorative justice through its variety approaches and restoring the offender in community by giving correctional practices, thereby giving everyone a second chance. There is no conflict without addressing the underlying emotions that gave rise to it and sustained it. While getting the two sides together to talk is not a normal part of the judicial process, and mediation makes it possible. Restorative justice, particularly community mediation programs, helps the victim heal. The inclusion of respected community members and the focus on maintaining social harmony underscores the Act's commitment to fostering the peaceful and cohesive community. Through these provisions, the Act promotes proactive approach to dispute resolution, enhancing the overall well-being of communities and preventing the escalation of conflicts. It promotes social harmony and access to justice for our ordinary citizens in a consensual and humanistic way against the background of adversarial system of judging who is right and who is wrong. So with this, we conclude the discussion on Chapter 10 of Mediation Act 2023. Thank you.